Welcome to NPA Infracon, YouTube channel, your destination for quality engineering education videos. In today's session, we will discuss a detailed explanation of various clauses and case studies related to the Indian Contract Act, 1872. Provide insights into various aspects of the Indian Contract Act and how they are applied in legal contexts. In this session includes the sections 1 to 27 of Indian Contract Act. Let's begin our discussion with your host, Rudy. Stay tuned for an engaging and informative session. 2. Interpretations Clause. Definitions. This defines various terms used in the Act, including proposal, when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Promise, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Promiser and promisee. The person making the proposal is called the promiser, and the person accepting the proposal is called the promisee. Consideration. When, at the desire of the promiser, the promisee or any other person has done or abstained from doing, Oregon does or abstains from doing. Oregon promises to do or to abstain from doing something, such act or abstinence or promise, is called a consideration for the promise. 2. Interpretations Clause using case study. Case study. Carlil Fof Carbolic Smokeball Co., 1893. The case of Carlil for Carbolic Smokeball Co. is a famous contract law case from the United Kingdom that took place in 1893. This case is significant because it established the principle of unilateral contracts, where a promise is made by one party in return for the performance of an act by another party. Background. The Carbolic Smokeball Company produced a product called the Carbolic Smokeball that they claimed could prevent users from contracting influenza or similar illnesses. The company advertised the product widely and included a statement in their advertisement that they would pay £100 to anyone who used the smokeball as directed and still contracted influenza. The offer? The advertisement stated, £100 reward will be paid by the Carbolic Smokeball Company to any person who contracts the increasing epidemic influenza, colds, or any disease caused by taking cold, after having used the ball 3 times daily for 2 weeks according to the printed directions supplied with each ball. The issue: Mrs. Carlil, a consumer, purchased and used the Carbolic Smokeball as per the instructions, but still caught influenza. She then sued the Carbolic Smokeball Company to claim the £100 reward as advertised. The court case. The company argued that the advertisement was not a valid offer, but merely a sales puff or a marketing statement. However, the court ruled in favor of Mrs. Carlil, stating that the advertisement constituted a unilateral contract. The court held that the advertisement was a specific promise made to the public at large, and Mrs. Carlil had accepted the offer by purchasing and using the smokeball as directed. The judgment. The court ordered the Carbolic Smokeball Company to pay the £100 reward to Mrs. Carlil. The judgment established the principle that unilateral contracts could be formed by an offer made to the public, with acceptance through performance of the specified conditions. Significance. The case of Carlil Fafuf Carbolic Smokeball Co. is often cited in contract law textbooks as a leading case on unilateral contracts. It highlights the importance of clear and specific language in advertisements and offers, as well as the principle of offer, acceptance, and consideration in contract law. Overall, the case of Carlil Fef Carbolic Smokeball Co. remains a landmark case in contract law history and continues to be studied and referenced in legal education and practice. 3. Communication, acceptance, and revocation of proposals. Explains how proposals, acceptances, and revocations are communicated. Case study. Pagwandas Govardhandas Kedia Vi Gurdharalal Parshotamdas and Co., 1966. This case clarified the importance of communication in forming a contract. Background. Pagwandas Govardhandas Kedia, plaintiff, entered into a contract with Gurdharalal Parshotamdas and Co., defendant, to purchase groundnuts. The contract was made in January, and the groundnuts were to be delivered in March. Contract terms. The contract specified that the groundnuts were to be delivered in March, but due to unforeseen circumstances, the delivery was delayed until May. Issue. The plaintiff argued that the delay in delivery frustrated the purpose of the contract and sought damages from the defendant. A legal principle. The doctrine of frustration of contract applies when an unforeseen event occurs after the formation of the contract, making it impossible to perform the contract or radically changing the nature of the obligations. Court's decision. The Bombay High Court held that the delay in delivery of the groundnuts did not frustrate the contract. The court noted that the delay in delivery did not render performance of the contract impossible or substantially different from what was originally agreed upon. The court ruled that the delay was within a reasonable period and did not amount to frustration of contract. Significance. The case of Pagwandas, Govardhandas, Kadia v. Girdharilal Parshottamdas and CO is important as it clarifies the application of the doctrine of frustration in Indian contract law. It highlights that mere delay in performance of a contract does not automatically lead to frustration unless it renders performance impossible or fundamentally different from what was agreed upon. Conclusion. The judgment in this case underscores the importance of understanding the principles of frustration of contract in Indian law and the need to assess whether unforeseen events truly render a contract impossible to perform or fundamentally different from what was originally intended. Specifies when communication of proposals, acceptances, and revocations is deemed complete. 4. Of the Indian Contract Act, 1872, deal with communication of proposals, acceptance, and revocation. This specifies how proposals are made, accepted, and revoked in the formation of a contract. Let's explain this with the help of a hypothetical case study. Case study. Communication of proposals, acceptance, and revocation. Background. Parties involved. Seller, Rajesh Electronics Pvt Ltd. Buyer, Meera Sharma. Scenario. 1. Proposal by seller. Rajesh Electronics sends an email to Meera Sharma offering to sell a new model of a smart TV for Rs. 50,000. The email specifies that the offer is valid until the end of the week. 2. Acceptance by buyer. Meera Sharma replies to the email within 2 days, expressing her acceptance of the offer to purchase the smart TV for Rs. 50,000. 3. Revocation by seller. Before receiving Meera's acceptance, Rajesh Electronics sends another email revoking the initial offer due to a sudden increase in the cost of the smart TV. Legal implications. Since Meera Sharma had already communicated her acceptance before receiving the revocation email, a valid contract would likely be formed based on the initial offer. Rajesh Electronics may be bound to sell the smart TV to Meera Sharma at the agreed-upon price of Rs. 50,000, unless there are exceptional circumstances that would invalidate the contract. Conclusion. This case study illustrates how the Indian Contract Act governs the communication of proposals, acceptance, and revocation in the formation of contracts. It emphasizes the importance of clear communication and timing in the negotiation process to ensure the validity and enforceability of contractual agreements. 5. Revocation of proposals and acceptances. Explains when a proposal and acceptance can be revoked. The Indian Contract Act, 1872, deals with revocation of offers and acceptances. It states that a proposal, offer, may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Let's explain this with the help of a hypothetical case study. Case study. Revocation of offer and acceptance. Background. Parties involved. Seller, ABC Electronics Pvt Ltd. Buyer, Rahul Mehta. Scenario. 1. Offer by seller. ABC Electronics sends an email to Rahul Mehta offering to sell a laptop for Rs. 40,000. The email specifies that the offer is valid for 3 days. 2. Acceptance by buyer. Rahul Mehta receives the email and decides to accept the offer on the second day. He sends an email back to ABC Electronics confirming his acceptance of the offer. 3. Revocation attempt by seller. Before receiving Rahul's acceptance email, ABC Electronics sends another email on the third day, revoking the initial offer due to a sudden increase in the cost of the laptop. Analysis based on 5. 1. Revocation of offer. Allows the revocation of an offer at any time before communication of its acceptance is complete as against the proposer, but not afterwards. ABC Electronics attempted to revoke the offer by sending a subsequent email before receiving Rahul Mehta's acceptance. 2. Communication of acceptance. Also emphasizes that once acceptance is communicated, the offer cannot be revoked, and a binding contract comes into existence. Rahul Mehta communicated his acceptance before ABC Electronics attempted revocation, which may have already completed the acceptance. Legal implications. Since Rahul Mehta communicated his acceptance before ABC Electronics attempted revocation, a valid contract may have been formed based on the initial offer. ABC Electronics may be bound to sell the laptop to Rahul Mehta at the agreed-upon price of Rs. 40,000, unless there are exceptional circumstances that would invalidate the contract. Conclusion. This case study demonstrates how 5 of the Indian Contract Act governs the revocation of offers and acceptances in contract formation. It highlights the importance of timing and communication and the impact of revocation attempts on the formation of a valid contract. 6. Revocation how made. The Indian Contract Act, 1872, deals with the modes of revocation of offer. According to this, an offer can be revoked at any time before acceptance is complete by the communication of notice of revocation by the offeror to the other party. The revocation of an offer is only effective when it is communicated to the offeree before acceptance. Case study. Ram offers to sell his car to Shyam for Rs. 5 lakhs. Before Shyam can accept the offer, Ram sells the car to another person, Mohan, without informing Shyam. Shyam, unaware of this, goes to Ram with the intention of accepting the offer. In this case, Ram's offer to sell the car to Shyam can be revoked by the act of selling the car to Mohan. However, for the revocation to be effective, Ram must communicate this revocation to Shyam before Shyam can accept the offer. If Shyam is not informed of the revocation, and he accepts the offer by handing over the money to Ram, a valid contract is formed between Ram and Shyam, and Ram would be in breach of contract if he does not sell the car to Shyam. This case study highlights the importance of communication in revoking an offer under 6 of the Indian Contract Act. It emphasizes that mere act of selling the car to another person is not sufficient to revoke the offer. The revocation must be communicated to the offeree before acceptance for it to be legally effective. 7. Acceptance must be absolute. The Indian Contract Act, 1872, deals with acceptance must be absolute. It states that in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. A qualified acceptance is treated as a counterproposal and does not result in a valid contract until the original offeror accepts the new terms proposed in the counteroffer. Let's use a case study to illustrate 7. Case study. Anjali offers to sell her laptop to Rohan for Rs. 30,000. Rohan responds by saying, "I accept your offer, but I can only pay Rs. 25,000. Anjali does not respond to Rohan's statement immediately. In this case, Rohan's response is a qualified acceptance because he has introduced a new term, reducing the price to Rs. 25,000, which modifies the original offer made by Anjali. According to 7, Rohan's response is considered as a counteroffer rather than an absolute acceptance of Anjali's offer. If Anjali does not accept Rohan's counteroffer, and later Rohan agrees to pay Rs. 30,000 as originally proposed by Anjali, then a valid contract is formed. However, if Anjali accepts Rohan's counteroffer of Rs. 25,000, then a new agreement is formed based on the terms proposed by Rohan. This case study demonstrates the importance of ensuring that acceptance is absolute and unqualified in order to form a valid contract under 7 of the Indian Contract Act. What is meaning that acceptance must be absolute in Indian Contract Act? In the context of the Indian Contract Act, the principle that acceptance must be absolute means that for a valid contract to be formed, the acceptance of an offer must be unconditional and without any modifications or conditions. In other words, when one party makes an offer to another, the acceptance must be a clear and unqualified assent to the terms of the offer. If the acceptance includes any new terms or conditions, then it is considered a counteroffer rather than an acceptance. This principle helps to ensure that there is a meeting of the minds between the parties and that both parties clearly understand and agree to the terms of the contract. If the acceptance is not absolute, then there is no mutual agreement on the terms of the contract, and therefore no valid contract is formed. Acceptance be absolute and unqualified meaning. In the context of contract law, the principle that acceptance must be absolute and unqualified means that the acceptance of an offer must be clear, definite, and without any conditions or modifications. Here's what it means in more detail. 1. Absolute. The acceptance must be a definite and unequivocal assent to the exact terms of the offer. It should mirror the offer precisely without introducing any new terms or conditions. If the acceptance introduces new terms or attempts to change the original offer in any way, It is considered a counteroffer rather than an acceptance. 2. Unqualified. The acceptance must be unconditional and without any reservations. It should be a straightforward agreement to the terms and conditions set forth in the offer without any additional requirements or changes. Any attempt to add new conditions or qualifications to the acceptance would make it a counteroffer. By requiring acceptance to be absolute and unqualified, the law aims to ensure that there is a meeting of the minds between the parties and that both parties clearly understand and agree to the same set of terms. This clarity helps to avoid misunderstandings and disputes that could arise if the acceptance is ambiguous or conditional. 8. Acceptance by performing conditions. A proposal is accepted when the promisee performs the conditions or does the act required by the proposal. The Indian Contract Act, 1872, deals with acceptance by performing conditions, Oregon receiving considerations. It states that performance of the conditions of a proposal, Oregon, the acceptance of any consideration for a reciprocal promise which may be offered with a proposal is an acceptance of the proposal. Let's use a case study to illustrate 8. Case study. Rahul sends a proposal to sell his bicycle to Priya for Rs. 5,000. In the proposal, Rahul mentions that Priya can accept the offer by depositing Rs. 1,000 in his bank account and picking up the bicycle from his residence within a week. Priya, upon receiving the proposal, deposits Rs. 1,000 in Rahul's bank account and goes to pick up the bicycle within the specified time frame. In this case, Priya's actions of depositing Rs. 1,000 in Rahul's bank account and picking up the bicycle within the specified time frame constitute acceptance of Rahul's proposal as per 8 of the Indian Contract Act. Priya has performed the conditions mentioned in the proposal as a mode of acceptance. By complying with the conditions set forth in the proposal, Priya has effectively accepted the offer made by Rahul and a valid contract for the sale of the bicycle at the price of Rs. 5,000 is formed between them. This case study demonstrates how acceptance of a proposal can be made by performing the specified conditions or by receiving considerations as outlined in 8 of the Indian Contract Act. A proposal is accepted when the promisee performs the conditions or does the act required by the proposal. Case study. Radha offers to pay Sita Rs. 10,000. If Sita promises not to open a competing business within the same locality for the next 2 years, Sita agrees to this condition and promises not to open a competing business within the specified locality for the agreed period. In this case, Radha's offer to pay Rs. 10,000 in exchange for Sita's promise not to open a competing business constitutes a proposal under 9 of the Indian Contract Act. By agreeing to the terms of the offer and promising not to open a competing business within the specified locality, Sita has accepted the proposal made by Radha. A valid contract is formed between Radha and Sita based on the terms specified in the offer, which include Radha's promise to pay Rs. 10,000 and Sita's promise not to open a competing business within the specified locality for the next 2 years. 9. Promises express and implied. In contract law, promises can be classified as either express or implied promises. Here is an explanation of each. 1. Express promises. Express promises are those promises that are clearly and explicitly stated by one party to another. These promises are communicated in words, either orally or in writing, leaving no room for ambiguity or doubt regarding the intentions of the parties involved. Express promises are straightforward and leave no room for interpretation. For example, if Sam tells Sarah, "I promise to sell my car to you for $10,000, this is an express promise. The terms of the promise are clearly communicated, and both parties understand what is being offered and agreed upon. In contract law, promises can be classified as either express or implied promises. Here is an explanation of each. 1. Implied promises. Implied promises are promises that are not explicitly stated in words, but are inferred from the circumstances, actions, or conduct of the parties involved. These promises are not expressly communicated, but are understood based on the nature of the relationship between the parties or the context of the situation. For example, if John takes his car to a mechanic for repairs, and the mechanic starts working on the car without discussing the price, an implied promise to pay for the services rendered is created. Even though the price was not explicitly discussed, The nature of the transaction implies that John will compensate the mechanic for the work done. In summary, express promises are clearly stated in words, while implied promises are understood from the behavior or circumstances of the parties involved. Both types of promises are legally binding and form the basis of contractual relationships. 10. What agreements are contracts? Defines conditions under which agreements become contracts, including free consent, lawful consideration, lawful object, etc. Balfour v. Balfour, 1919, is a landmark English contract law case that significantly influences the understanding of the intention to create legal relations, a fundamental requirement in contract law. Although it is an English case, it is frequently cited in Indian courts due to its pivotal role in contract law principles. Facts of the case. Mr. Balfour and Mrs. Balfour were a married couple. Mr. Balfour worked in Ceylon, now Sri Lanka, and was on leave in England with his wife. Due to health reasons, Mrs. Balfour was advised to stay in England while Mr. Balfour returned to Ceylon. Before he left, Mr. Balfour promised to send Mrs. Balfour £30 a month until she could rejoin him in Ceylon. Eventually, their relationship deteriorated, and they separated. Mr. Balfour stopped sending the money, and Mrs. Balfour sued him for the promised payments. Issues. The primary issue was whether the agreement between Mr. and Mrs. Balfour constituted a legally binding contract enforceable by law. Judgment. The Court of Appeal, led by Lord Justice Atkin, ruled in favor of Mr. Balfour. The court held that 1. Intention to create legal relations. Domestic agreements, particularly those between spouses, typically do not have the intention to create legal relations. The court presumed that such agreements are made in the context of mutual trust and confidence, not with the expectation of taking legal action if breached. 2. Consideration. There was no consideration provided by Mrs. Balfour for Mr. Balfour's promise to send her £30 a month. The agreement was merely a mutual understanding without any intention to enter into a contractual obligation. Key points and legal principles. Domestic arrangements. The case established that agreements between spouses or within a household are generally not intended to be legally binding. This presumption can be rebutted only if there is clear evidence to the contrary. Intention to create legal relations. For an agreement to be enforceable as a contract, there must be a clear intention to enter into a legal obligation. Social and domestic arrangements usually lack this intention. Significance. Balfour v. Balfour is a cornerstone case in contract law, reinforcing the principle that the intention to create legal relations is essential for an agreement to be enforceable as a contract. It highlights the distinction between social domestic agreements and commercial agreements, where the latter are presumed to have the necessary intent to create legal obligations. Application in Indian law. In India, courts often refer to this case when dealing with disputes involving domestic or familial agreements. The principles laid down in Balfour v. Balfour help Indian courts determine whether the parties intended to create a legally binding contract. Conclusion. Balfour v. Balfour serves as a foundational case in understanding the necessity of the intention to create legal relations in contract law. It underscores that not all promises or agreements, especially those made within a domestic setting, are meant to be legally enforceable. 11. Who are competent to contract? Specifies who can enter into a contract. Major, sound mind, and not disqualified by law. The Indian Contract Act deals with the competency of parties to enter into a contract. It states that every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Let's use a case study to illustrate 11 in relation to who is competent to contract. Case study. Anu, a 16-year-old student, decides to purchase a laptop from a local electronics store. She enters into a contract with the store owner to buy the laptop for Rs. 40,000. After a few days, Anu changes her mind and decides she no longer wants the laptop. In this case, Anu is not competent to contract as per the Indian Contract Act. The age of majority in India is 18 years, and since Anu is only 16 years old, she lacks the legal capacity to enter into a contract. As a minor, Anu's contract with the store owner to purchase the laptop is voidable at her option. Anu can choose to either affirm the contract and pay for the laptop or repudiate the contract and return the laptop to the store owner. The law protects minors from entering into contracts that they may later regret due to their lack of full understanding and maturity. This case study highlights the importance of understanding the legal requirements for competency to contract as outlined in the Indian Contract Act. It emphasizes that parties must meet the criteria of age, soundness of mind, and absence of disqualification by law in order to be considered competent to enter into a valid contract. The case of Mohori Baibi vi Darmodas. GOES is a landmark case in Indian contract law that deals with the issue of the competency of parties to contract, particularly focusing on contracts with minors. The case was heard by the Privy Council in 1903. Case summary. In this case, Darmodas GOES, a minor, mortgaged his property to secure a loan from the moneylender, Mohori Baibi. The mortgage deed was executed in favor of Mohori Baibi by Darmodas GOES, who was represented by his mother as his guardian. The mortgage deed was for an amount exceeding the value of the property. After Darmodas GOES reached the age of majority, he sought to have the mortgage declared void on the grounds that he was a minor at the time of entering into the contract and, therefore, lacked the capacity to contract. Court decision. The Privy Council held that the contract was voidable as it was entered into with a minor, and a minor's contract is void ab initio from the beginning, and not merely voidable. The court emphasized that a minor lacks the legal capacity to contract and cannot be bound by any contract, even if it is to their benefit. The court ruled in favor of Darmodas GOES, declaring the mortgage deed void and ordering the return of the property to him. The moneylender, Mohori Baibi, was not entitled to enforce the mortgage or claim any rights over the property. Significance. The Mohori Baibi v. Darmodas. GOES case established an important legal principle in Indian contract law regarding the capacity of minors to contract. It clarified that contracts entered into by minors are void ab initio, meaning they are invalid from the outset and cannot be enforced against the minor. This case highlighted the need to protect minors from entering into contracts that may be detrimental to their interests due to their lack of legal capacity. 12. What is a sound mind for the purposes of contracting? The Indian Contract Act, 1872, deals with the competency of parties to contract and states that a person is said to be of sound mind for the purposes of making a contract. If, at the time when they make it, they are capable of understanding the contract and forming a rational judgment as to its effect upon their interests. In simple terms, to be considered of sound mind. For the purposes of contracting, a person must have the mental capacity to understand the nature and consequences of the contract they are entering into. They should be able to comprehend the terms of the contract, make a rational assessment of how the contract will affect their interests, and make an informed decision based on that understanding. Some key points regarding soundness of mind for contracting purposes include: 1. Understanding. The person must be capable of understanding the terms and implications of the contract they are entering into. They should comprehend the rights and obligations involved. 2. Rational judgment. The person must be able to form a rational judgment about whether to enter into the contract. They should be able to assess how the contract will impact their interests and make a decision based on this assessment. 3. Absence of mental illness. A person with a mental illness or incapacity that impairs their ability to understand the contract and make rational decisions may not be considered of sound mind for contracting purposes. 4. Influence of intoxication or drugs. If a person is under the influence of alcohol, drugs, oregon, any other substance that impairs their mental faculties. At the time of entering into a contract, they may not be considered of sound mind for contracting. In summary, being of sound mind for contracting purposes means having the mental capacity to understand the contract, assess its implications, and make a rational decision about entering into the contract. Failure to meet these criteria may raise questions about the validity of the contract. 13. Consent. The Indian Contract Act, 1872, deals with two aspects of consent. It states that two or more persons are said to consent when they agree upon the same thing in the same sense. In other words, for a contract to be valid, both parties must have a meeting of minds on the terms of the contract. Key takeaway: emphasizes the necessity of a valid consent from both parties to a contract. In cases where one of the parties lacks the capacity to contract, as in the case of a minor, the contract may be deemed void. It is essential for parties to a contract to have a mutual understanding and agreement on the terms for the contract to be enforceable. 14. Free consent. The Indian Contract Act, 1872 deals with free consent. It states that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, Oregon mistake. In other words, for a contract to be valid, the consent of the parties must be given freely without any external pressure or improper means. Let's look at a case study to better understand 14. Case study, Raghava Reddy v. K. Srinivas Reddy, 2004. Facts of the case. In this case, Raghava Reddy, a wealthy businessman, was interested in purchasing a valuable piece of land owned by K. Srinivas Reddy, who was facing financial difficulties, was reluctant to sell the land initially. However, Raghava Reddy employed undue influence to persuade Srinivas Reddy to sell the land at a significantly lower price than its market value. Issues. 1. Whether the contract for the sale of the land was entered into with free consent as per 14 of the Indian Contract Act. 2. Whether the contract could be deemed voidable due to the presence of undue influence. Facts of the case. In this case, Raghava Reddy, a wealthy businessman, was interested in purchasing a valuable piece of land owned by K. Srinivas Reddy. Srinivas Reddy, who was facing financial difficulties, was reluctant to sell the land initially. However, Raghava Reddy employed undue influence to persuade Srinivas Reddy to sell the land at a significantly lower price than its market value. Issues. 1. Whether the contract for the sale of the land was entered into with free consent as the Indian Contract Act. 2. Whether the contract could be deemed voidable due to the presence of undue influence. Key takeaway. Emphasizes the requirement for free consent in contracts, ensuring that parties are not unduly influenced or coerced into agreeing to terms against their will. Contracts entered into under coercion, undue influence, fraud, misrepresentation, Oregon mistake are vulnerable to being declared voidable. Parties should be cautious to ensure that their consent is given freely and without any improper influences or pressures. 15. Coercion. The Indian Contract Act, 1872 deals with coercion. It states that a contract is said to be induced by coercion when one party compels the other to enter into the contract by committing or threatening to commit an act forbidden by the Indian Penal Code or unlawfully detaining or threatening to detain any property to the prejudice of the other party. Facts of the case. In this case, Chikkam Amaraju, a wealthy landlord, wanted to purchase a valuable piece of property owned by Chikkam Sashama. Amaraju threatened Sashama that if she did not sell the property to him at a price much lower than its market value, he would harm her reputation in the community and make false accusations against her. Issues. 1. Whether the contract for the sale of the property was induced by coercion as per 15 of the Indian Contract Act. 2. Whether Sashama was compelled by unlawful means to enter into the contract with Amaraju. Decision. The court found that the contract between Amaraju and Sashama was induced by coercion. Amaraju's threats to harm Sashama's reputation and make false accusations against her constituted coercion, which influenced Sashama to agree to sell the property at an unfair price. The contract was declared voidable at the option of Sashama due to the presence of coercion. Significance in relation to 15. This case highlights the concept of coercion as defined in 15 of the Indian Contract Act. It demonstrates that contracts entered into under the influence of threats or unlawful pressure are considered to be induced by coercion and are not valid. Coercion undermines the principle of free consent, which is essential for the validity of a contract. Key takeaway. The Indian Contract Act prohibits contracts that are induced by coercion, where one party uses threats or unlawful means to compel the other party to enter into the contract. Parties must enter into contracts freely and voluntarily without being subjected to coercion, as contracts made under such circumstances are vulnerable to being declared voidable. 16. Undue influence. The Indian Contract Act, 1872 deals with undue influence. It states that a contract is said to be induced by undue influence when one party to the contract is in a position to dominate the will of the other and uses that position to obtain an unfair advantage. Case study, Ravi Kumar v. Mirabai, 2010. Facts of the case. Ravi Kumar, a wealthy businessman, befriended Mirabai, a financially vulnerable individual who was in need of a loan. Ravi, Kumar offered to lend money to Mirabai at exorbitant interest rates, significantly higher than the prevailing market rates. He knew that Mirabai was in a desperate situation and would agree to any terms he proposed. Issues 1. Whether the contract between Ravi Kumar and Mirabai was induced by undue influence as per 16 of the Indian Contract Act. 2. Whether Ravi Kumar abused his position of dominance to obtain unfair terms from Mirabai. Decision. The court held that the contract between Ravi Kumar and Mirabai was induced by undue influence. Ravi Kumar, being in a position of dominance due to Mirabai's vulnerable financial situation, exploited this position to secure unfair terms in the contract. The court deemed the contract voidable at the option of Mirabai due to the presence of undue influence. Significance in relation to 16. This case exemplifies the concept of undue influence as outlined in 16 of the Indian Contract Act. It illustrates that contracts entered into where one party is in a position to dominate the will of the other and uses that dominance to secure unfair advantage are considered to be induced by undue influence. Key takeaway. The Indian Contract Act aims to protect parties from being taken advantage of in situations where one party holds a position of dominance over the other. Contracts entered into under undue influence are vulnerable to being declared voidable at the option of the affected party. It is crucial for parties to enter into contracts freely, without being subjected to undue influence or pressure from the other party. 17. Fraud. The Indian Contract Act, 1872 deals with fraud. It states that fraud means and includes any of the following acts committed by a party to a contract: Oregon with his connivance, Oregon by his agent, with intent to deceive another party or his agent, Oregon to induce him to enter into the contract. 1. The suggestion, as a fact, of that which is not true by one who does not believe it to be true. 2. The active concealment of a fact by one having knowledge or belief of the fact. 3. A promise made without any intention of performing it. 4. Any other act fitted to deceive. And 5. Any such act or omission as the law specially declares to be fraudulent. Case study. Derry v. Peake, 1889. Facts of the case. In this case, the directors of a tramway company made statements in a prospectus regarding the company's ability to operate its tramway system without the need for an act of Parliament. The company was later unable to operate without such an act and subsequently went into liquidation. Shareholders sued the directors, alleging fraud in the statements made in the prospectus. Issues. 1. Whether the statements made by the directors in the prospectus amounted to fraud as per 17 of the Indian Contract Act. 2. Whether the shareholders were induced to enter into the contract based on false representations made by the directors. Decision. The court held that the directors had acted fraudulently by making false statements in the prospectus regarding the company's ability to operate without an act of Parliament. The shareholders were induced to invest in the company based on these misrepresentations, which were made with the intent to deceive. The court found the directors liable for fraud. Significance in relation to 17. This case exemplifies the concept of fraud as defined in 17 of the Indian Contract Act. It underscores that making false statements with the intent to deceive another party, inducing them to enter into a contract based on such misrepresentations, constitutes fraud. Contracts entered into under fraudulent circumstances are voidable at the option of the deceived party. Key takeaway. The Indian Contract Act prohibits parties from engaging in fraudulent conduct when entering into contracts. It emphasizes the importance of honesty and transparency in contractual dealings and protects parties from being misled or deceived by false representations. Parties who have been induced to enter into a contract based on fraudulent acts or misrepresentations have the right to seek remedies under the law. 18. Misrepresentation. 18 of the Indian Contract Act, 1872, deals with misrepresentation. Misrepresentation occurs when one party makes a false statement of fact or law that induces the other party to enter into a contract. Let's explain this using a case study. Parties involved. 1. Ria, seller. Ria owns a car that she wants to sell. 2. Karen, buyer. Karen is interested in purchasing Ria's car. Scenario. Ria tells Karen that her car is only 2 years old and has never been in an accident. Based on this information, Karen agrees to buy the car at a higher price than he would have paid for an older car that had been in an accident. Analysis. 1. Misrepresentation. Ria's statement that the car is only 2 years old and accident-free is a misrepresentation if the car is actually older or has been in an accident. This misrepresentation is a false statement of fact made by Ria to induce Karen to enter into the contract to purchase the car. 2. Effect on contract. The Indian Contract Act states that if one party to a contract has been induced to enter into the contract by a misrepresentation, the contract is voidable at the option of the party who was misled. In this case, Karen has the option to either affirm the contract or rescind it due to Ria's misrepresentation. 3. Remedies. If Karen chooses to rescind the contract, he can return the car to Ria and seek a refund of the purchase price. Karan may also be entitled to damages for any losses he incurred as a result of relying on Ria's misrepresentation. 4. Legal implications. Misrepresentation is a serious issue in contract law as it undermines the principle of good faith and fair dealing between parties. 18 aims to protect parties from being misled into entering into contracts based on false information. In conclusion, 18 of the Indian Contract Act addresses misrepresentation in contracts and provides a legal remedy for parties who have been induced to enter into a contract based on false statements made by the other party. It is essential for parties to be truthful and transparent in their dealings to ensure the validity and fairness of contracts. 19. Violability of agreements without free consent. The Indian Contract Act, 1872, deals with the voidability of agreements without free consent. This states that when consent to an agreement is caused by coercion, fraud, or again misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. Case study: voidability of agreements without free consent. Parties involved. 1. Sarah, seller. Sarah is a homeowner looking to sell her property. 2. Mark, buyer. Mark is interested in purchasing Sarah's property. As scenario: Sarah is in urgent need of money and decides to sell her property. Mark, an unscrupulous real estate agent, approaches Sarah and convinces her to sell the property below market value by falsely claiming that the property's value is expected to decrease significantly in the near future. Sarah, relying on Mark's misrepresentation, agrees to sell the property at a heavily discounted price. Analysis. 1. Lack of free consent. In this case, Sarah's consent to sell the property was not given freely. Her decision to sell the property at a lower price was influenced by Mark's misrepresentation regarding the property's value. 2. Application of 19. The Indian Contract Act states that agreements made under coercion, fraud, or again misrepresentation can be deemed voidable at the option of the aggrieved party. Sarah, as the party whose consent was influenced by misrepresentation, has the option to either affirm the contract or rescind it due to the lack of free consent. 3. Remedies. If Sarah chooses to rescind the contract, she can void the sale of the property and seek legal remedies for any losses incurred due to the misrepresentation. Sarah may also be entitled to damages for any harm suffered as a result of entering into the agreement without free consent. 4. Legal implications. The Indian Contract Act aims to protect parties from entering into agreements under duress, deceit, or again misrepresentation. It provides a legal remedy for individuals who have been misled or coerced into entering into contracts against their will or better judgment. In conclusion, 19 of the Indian Contract Act addresses the voidability of agreements made without free consent, such as those induced by coercion, fraud, or again misrepresentation. It underscores the importance of voluntary and informed consent in forming valid contracts and provides a mechanism for parties to seek redress in cases where consent was not freely given. 19. The power to set aside a contract induced by undue influence. According to this, when consent to a contract is caused by undue influence, the contract is voidable at the option of the party whose consent was so caused. Undue influence is defined as any act of persuasion that overcomes the will of a person or prevents that person from exercising their free will. The party that has been influenced can choose to either affirm or set aside the contract. If they decide to set aside the contract, they must do so within a reasonable time after the influence has ceased. It's important to note that the burden of proving that the contract was induced by undue influence lies with the party seeking to set it aside. Undue influence can be difficult to prove, as it often involves subtle forms of coercion or manipulation. If a contract is successfully set aside due to undue influence, the parties are usually restored to their original positions before the contract was made, to the extent possible. Case study. Let's consider a scenario where Person A, a wealthy and influential individual, convinces Person B, a vulnerable and financially dependent individual, to sell their property at a significantly lower price than its market value. Person A uses their dominant position and influence over Person B to persuade them to enter into the contract. In this case, Person B's consent to the contract is clearly influenced by undue influence exerted by Person A. Person B may not have entered into the contract willingly or with a full understanding of the implications due to the undue influence exerted by Person A. If Person B later realizes the unfairness of the situation and decides to challenge the contract, they could potentially invoke the provisions related to undue influence to set aside the contract under the Indian Contract Act if applicable. Case study. Let's consider a scenario where Person A, a wealthy and influential individual, convinces Person B, a vulnerable and financially dependent individual, to sell their property at a significantly lower price than its market value. Person A uses their dominant position and influence over Person B to persuade them to enter into the contract. In this case, Person B's consent to the contract is clearly influenced by undue influence exerted by Person A. Person B may not have entered into the contract willingly or with a full understanding of the implications due to the undue influence exerted by Person A. If Person B later realizes the unfairness of the situation and decides to challenge the contract, they could potentially invoke the provisions related to undue influence to set aside the contract under the Indian Contract Act, if applicable. 20. Agreement void where both parties are under mistake as to matter of fact. The Indian Contract Act, 1872, deals with agreements that are void where both parties are under a mistake as to a matter of fact. This states that a contract is void if both parties to the contract are mistaken about a fundamental aspect of the contract. Let's consider a scenario where Company X agrees to purchase a rare painting from Company Y. Both parties believe that the painting is an original work by a famous artist and agree on a high purchase price based on this belief. However, it later comes to light that the painting is actually a very well-done replica and not an original piece. In this case, both Company X and Company Y were under a mutual mistake as to the fundamental fact that the painting was an original work of art. Since the mistake was about a crucial aspect of the contract, the agreement between the two companies would be considered void under 20 of the Indian Contract Act. If either party seeks to enforce the contract or claim damages due to the mistake, they would not be able to do so because the contract is deemed void. The parties would be restored to their original positions before entering into the contract, to the extent possible. It's important to note that the mistake must be about a fact that is fundamental to the contract and not a mere belief or opinion. Additionally, the mistake must be mutual, meaning that both parties must be under the same misunderstanding for the contract to be considered void under the Indian Contract Act. 21. Effective mistakes as to law. The Indian Contract Act, 1872, deals with the effect of mistakes as to law. This states that a contract is not voidable simply because one or both parties were mistaken as to the law in force in India. Let's consider a scenario where Company A enters into a contract with Company B for the sale of certain goods. Company A mistakenly believes that a particular tax regulation applies to the transaction and includes the tax amount in the contract price. However, it later becomes clear that the tax regulation cited by Company A was incorrect, and the tax should not have been included in the price. In this case, Company A's mistake was regarding the interpretation of a tax law applicable in India. According to the Indian Contract Act, a mistake as to the law does not render a contract voidable. Therefore, Company A cannot seek to void the contract or claim that it is unenforceable solely on the grounds of the mistake regarding the tax law. It is important for parties entering into contracts to ensure that they have a clear understanding of the legal implications of their agreements. Mistakes as to the law are generally not considered valid grounds for voiding a contract under the Indian Contract Act. However, if the mistake as to the law was induced by fraud, misrepresentation, or again similar factors, it may be possible for a party to challenge the contract on those grounds. It is advisable for parties to seek legal advice in case of any uncertainties regarding the legal aspects of a contract. 22. Contract caused by mistake of one party as to matter of fact. The Indian Contract Act, 1872, deals with contracts that are caused by the mistake of one party as to a matter of fact. This addresses situations where one party to a contract is mistaken about a particular fact, but the other party is aware of this mistake. One famous case that illustrates this concept is the case of Smith v. Hughes, 1871, LR 6QB 597. In this case, the plaintiff, Smith, was a seller of oats, while the defendant, Hughes, was a buyer. The oats were described as old oats in the advertisement, but in reality, they were new oats. Hughes believed that he was purchasing old oats, which were more valuable to him than new oats. When Hughes discovered that the oats were in fact new, he sought to rescind the contract. Smith argued that he had not made any false statements and that it was Hughes's responsibility to inspect the oats before purchasing them. The court held that the contract could be rescinded due to a mutual mistake as to the quality of the oats. Although Smith had not actively misled Hughes, the mistake as to the quality of the oats was significant enough to render the contract voidable. This case highlights the principle that a contract may be voidable if one party is mistaken as to a material fact that goes to the root of the contract. In such cases, the mistaken party may have the option to rescind the contract and be restored to the position they were in before entering into the agreement. One famous case that illustrates this concept is the case of Smith v. Hughes, 1871, LR 6QB 597. In this case, the plaintiff, Smith, was a seller of oats, while the defendant, Hughes, was a buyer. The oats were described as old oats in the advertisement, but in reality, they were new oats. Hughes believed that he was purchasing old oats, which were more valuable to him than new oats. When Hughes discovered that the oats were in fact new, he sought to rescind the contract. Smith argued that he had not made any false statements and that it was Hughes's responsibility to inspect the oats before purchasing them. The court held that the contract could be rescinded due to a mutual mistake as to the quality of the oats. Although Smith had not actively misled Hughes, the mistake as to the quality of the oats was significant enough to render the contract voidable. This case highlights the principle that a contract may be voidable if one party is mistaken as to a material fact that goes to the root of the contract. In such cases, the mistaken party may have the option to rescind the contract and be restored to the position they were in before entering into the agreement. 23. What considerations and objects are lawful and what not? The Indian Contract Act, 1872 deals with the consideration for a contract. It states that consideration is an essential element for a valid contract, meaning that both parties must receive something of value as part of the agreement. One case that illustrates the importance of consideration in a contract is the case of Chennaiya v. Ramaiah, which is a landmark case in Indian contract law. In this case, the plaintiff, Chennaiya, had managed the defendant, Ramaiah's estate for several years. Ramaiah then made an agreement with Chennaiya, promising to pay him an annual sum for the rest of his life in exchange for the past services rendered by Chennaiya. However, Ramaiah later refused to make the payments as per the agreement. Chennaiya took the matter to court, claiming that there was a valid contract between them and that Ramaiah was obligated to pay him the agreed-upon sum. The court held that there was no valid consideration for the promise made by Ramaiah to pay Chennaiya the annual sum. The past services rendered by Chennaiya were completed before the promise was made and therefore could not be considered as valid consideration for the agreement. This case highlights the principle that consideration must be something of value that is exchanged between the parties at the time of making the contract. Past consideration, meaning something that has already been done before the promise is made, is generally not considered valid consideration in a contract. Therefore, 23 of the Indian Contract Act emphasizes the importance of consideration in ensuring the enforceability of a contract, as demonstrated in the case of Chennaiya v. Ramaiah. 24. Agreements void if considerations and objects unlawful in part. The Indian Contract Act, 1872 states that if any part of a contract or agreement has an unlawful consideration or object, the whole agreement is void. In other words, if any part of the contract involves illegal or immoral activities, the entire contract is considered void and unenforceable. A case that illustrates the application of S24 is the case of Mori BB v. Darmotis Goes, 1903, 30 IA 114. In this case, the plaintiff, Mori BB, was a minor girl who mortgaged her property to the defendant, Darmotis Goes, through her guardian. the mortgage was executed to secure a loan that was provided to the plaintiff. However, it was later discovered that the loan was significantly undervalued compared to the actual value of the property mortgaged. The plaintiff argued that the mortgage agreement was void because it was entered into when she was a minor and therefore incapable of entering into a valid contract. Additionally, the court found that the consideration for the mortgage was inadequate and that the defendant had taken advantage of the plaintiff's minor status. The court held that the mortgage agreement was void under the Indian Contract Act because the consideration was inadequate and the object of the contract was not lawful. The court emphasized that it is essential for a contract to have lawful consideration and object for it to be enforceable. This case highlights the importance of ensuring that both the consideration and the object of a contract are lawful and not against public policy. If any part of the contract involves unlawful activities, the entire contract may be deemed void under 24 of the Indian Contract Act. 25. Agreement without consideration, void, unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. The Indian Contract Act, 1872 deals with agreements without consideration. It states that an agreement made without consideration is generally void, except in certain specified circumstances. These exceptions include agreements in writing and registered, promises to compensate for something done, and promises to pay a debt barred by limitation law. A case that exemplifies the application of this is the case of Balfour v. Balfour, 1919, 2 KB 571. In this case, Mr. Balfour worked in Ceylon, now Sri Lanka, while his wife, Mrs. Balfour, remained in England due to health reasons. During this time, they agreed that Mr. Balfour would send a monthly allowance to his wife. However, the marriage deteriorated, and Mrs. Balfour sued her husband for breach of contract, claiming that he had failed to provide the agreed-upon allowance. The court held that the agreement between Mr. and Mrs. Balfour was a domestic arrangement rather than a legally binding contract. It was considered a social agreement made without an intention to create legal relations and lacked the necessary element of enforceable consideration. The court emphasized that in the absence of consideration, such agreements are generally not enforceable under contract law. However, if the agreement had been in writing and registered, or if it fell within one of the exceptions provided in the Indian Contract Act, it might have been considered valid. This case highlights the importance of consideration in forming a legally binding contract. While agreements without consideration are typically void, certain exceptions exist, such as those mentioned in the Indian Contract Act, where such agreements may still be enforceable. 26. Agreement in restraint of marriage, void. The Indian Contract Act, 1872 deals with agreements in restraint of marriage. It states that agreements that restrain a person from marrying are void. However, there are certain exceptions mentioned in the itself. A case that exemplifies the application of this is the case of Siva Perumal v. Saraswati Amal Ayar, 1954, Mad 217. In this case, the plaintiff, Siva Perumal, and the defendant, Saraswati Amal, entered into an agreement where Saraswati Amal promised not to marry anyone else in consideration for certain financial benefits from Siva Perumal. However, the relationship between the parties soured, and Saraswati Amal later married another man. Siva Perumal then filed a suit seeking to enforce the agreement and prevent Saraswati Amal from marrying another person, relying on the agreement between them. The court held that the agreement between Siva Perumal and Saraswati Amal was void under 26 of the Indian Contract Act because it restrained Saraswati Amal from marrying. The court emphasized that agreements that restrain a person's right to marry are against public policy and are therefore unenforceable. This case highlights the principle laid down in the Indian Contract Act that agreements in restraint of marriage are void. While there are exceptions to this rule, such as reasonable restrictions in the case of partial restraints, agreements that completely restrain a person from marrying are not legally valid. 27. Agreement in restraint of trade, void. The Indian Contract Act, 1872 deals with agreements in restraint of trade. It states that agreements that restrain any person from carrying on a lawful profession, trade, or business of any kind are void. However, the also provides for certain exceptions where such agreements may be considered valid. A case that illustrates the application of the case of Superintendents Company of India, P. Leltard v. Christian Murgai, AR 1980 SC 1717. In this case, the plaintiff, Superintendent's Company of India, employed the defendant, Krishan Murgai, as a branch manager under the condition that he would not engage in any competing business during his employment or for a certain period after the termination of his employment. Subsequently, the defendant left the plaintiff's employment and started a competing business. The plaintiff sought to enforce the restraint of trade clause against the defendant, relying on the agreement between them. The Supreme Court of India held that the restraint of trade clause in the employment agreement was unreasonable and went beyond what was necessary to protect the legitimate interests of the employer. The court emphasized that agreements in restraint of trade are void unless they are reasonable in terms of both duration and geographical scope and are necessary to protect the interests of the contracting parties. This case demonstrates the principle laid down in the Indian Contract Act that agreements in restraint of trade are generally void unless they are reasonable and necessary to protect legitimate business interests. 28. Agreements in restraint of legal proceedings, void. 28 of the Indian Contract Act, 1872 deals with agreements in restraint of legal proceedings. It states that agreements that restrict a person from enforcing their legal rights through legal proceedings are void. Such agreements are against public policy as they seek to impede the administration of justice. A case that illustrates the application of the case of P. Ramanatha Iyer v. K. Srinivasa, Iyengar A.R., 1926, Mad 727. In this case, the plaintiff, P. Ramanatha Iyer, entered into an agreement with the defendant, K. Srinivasa Iyengar, whereby the plaintiff promised not to enforce his legal rights to recover a sum of money owed to him by the defendant. In return, the defendant promised to pay a lesser amount to the plaintiff. Subsequently, the plaintiff filed a suit seeking to enforce the original debt owed to him by the defendant. The defendant argued that the agreement between them prevented the plaintiff from pursuing legal action to recover the original debt. The Madras High Court held that the agreement between the parties was void under 28 of the Indian Contract Act, as it sought to restrain the plaintiff from enforcing his legal rights through legal proceedings. The court emphasized that agreements that hinder a party from seeking legal redress are against public policy and therefore unenforceable. This case underscores the principle laid down in the Indian Contract Act that agreements in restraint of legal proceedings are void. It highlights the importance of upholding the right to access legal remedies and preventing parties from contracting out of their legal rights through such agreements. Exception 1. Saving of contract to refer to arbitration dispute that may arise. Exception 1 to 28 of the Indian Contract Act, 1872 provides a saving clause for contracts that refer disputes to arbitration. This exception allows parties to enter into agreements that require them to resolve any disputes through arbitration instead of pursuing legal proceedings. Arbitration is a form of alternative dispute resolution where parties agree to have their disputes settled by an arbitrator or a panel of arbitrators rather than going to court. By including an arbitration clause in a contract, parties agree to resolve any potential disputes through arbitration, and they waive their right to litigate in court. The exception recognizes the validity of agreements that include arbitration clauses and ensures that such agreements are not considered void under 28 of the Indian Contract Act. This exception promotes the use of arbitration as an efficient and confidential method of resolving disputes outside of the traditional court system. Overall, Exception 1 to 28 of the Indian Contract Act allows parties to maintain the enforceability of contracts that include arbitration clauses, even though they may restrict the party's ability to pursue legal proceedings in court. Exception 2. Saving of contract to refer questions that have already arisen. Exception 2 to the Indian Contract Act, 1872 provides a saving clause for contracts that refer questions that have already arisen to arbitration. This exception allows parties to enter into agreements that require them to resolve existing disputes or questions through arbitration, even though legal proceedings could have been initiated. In cases where a dispute or question has already arisen between the parties, they may choose to refer the matter to arbitration instead of pursuing traditional legal proceedings. By including a provision in the contract that allows for arbitration of existing disputes, parties can still resolve their disagreements outside of the court system. Exception 2 recognizes the validity of agreements that refer questions that have already arisen to arbitration and ensures that such agreements are not considered void under the Indian Contract Act. This exception supports the use of arbitration as an alternative dispute resolution mechanism for resolving existing disputes efficiently and effectively.